Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Hey everyone, welcome back to an all-new episode of the Atlanta Business and Commercial Real Estate Law Podcast with attorney Mark Battleson over at Battleson Law LLC. I am your host, Mike Leon. You know, Mark here brings over 3 decades of experience all across business law, commercial real estate, deal structuring, and he's got a background that includes not only the legal work, but the hands-on business roles work. Today's episode, we're going to be talking about what buyers and sellers should understand when a small business change hands from the early negotiation parts through the closing. Mark's going to break this all down in just a second. Mark, it's good to see you. And let me ask you at the high level here, someone's thinking about buying or selling a small business now as they're listening to this. How do brokers kind of fit into the process? What should people kind of clarify with that broker before they actually are relying on that broker?
Thanks, Mike, and good to see you. Brokers are salespeople, so they can be helpful in educating a seller or a buyer on what the marketplace is for a particular business. It really depends on the audience let's say you're a seller. Depends on what the audience that you're looking to present to is. If you know your industry and you know who might be an acquirer of your business, maybe reaching out to them quietly and privately is a better way for you to go, especially if you have employees that you're worried about catching wind of a transaction, et cetera. And again, I work in super small business. I mean, micro businesses all the way up to lower middle market. So the politics of it differs. You know, if it's a mom and pop in a retail shopping center with 1,000 square feet and they're making $500,000 a year versus a $20 million company or something like that. So, but the broker can help inform assuming you've got a good one that understands your industry, et cetera, and understands the transaction history and things like that. They can help you understand how to, the possibility of selling your business, the structure and the pricing associated with selling your business, and then who to market it to. The smaller the business, you may have to do just a broad public marketing, but a lot of it might be more bespoke or, kind of pocket listing kind of, marketing. On the buy side, hiring a broker is a little more traditional for the first-time business buyer to go out and just kind of comb the universe to try to find a business for somebody who wants to be an entrepreneur. Typically, they're going to be focused within a particular area. There's people that are franchise acquisition people or franchise salespeople that actually aggregate. They work for multiple franchisors trying to sell a franchise opportunity. Sometimes that's an existing business. Most of the time it's a new location because franchises are about growth. So what can a broker do for you? Just it's a funnel, deal flow. I wouldn't rely on a broker to make legal decisions, financial decisions, et cetera. These are salespeople. They want to get a deal done. They very likely aren't getting paid unless they get a deal done. So take them for what they're worth, which is education on some level, and then being a funnel for deal flow or buyer flow for you.
Let me ask you, because you mentioned a range of like a small mom and pop, $500,000 a year versus like a $20 million business. And obviously that speaks to valuation, right? And that's a big focus. How would you advise, or what should buyers and sellers think about value, especially when they're comparing the financials, the historical financials of the business with pro forma projections?
Right. Well, pro forma projections had better be yours. Pro forma means the future, essentially. It's a Latin term, to where you take a look at the history of a company, and hopefully they've got good records. I mean, if somebody's dealing in cash, which is less common these days, but cash businesses, if they aren't claiming all of that on their tax returns, don't give them credit for it if you're a buyer. If you've got taking a look at a business, you're going to value it on kind of like real estate, where there may be some physical assets and then there are intangible assets, and you would benchmark that off of multiple ways on how to value. You could just look at what's the breakup value of the company, and then whatever amount you're willing to pay for more than that is the goodwill or intangibles. And so let's say you've got $400,000 of equipment you're buying, and then you think the goodwill, customer lists, cash flow, basically the operations of the business, that's worth 600,000 to you, then it's $1 million. It's usually based off the revenue, though, or profit of a business. You can, a revenue multiple 1 times, 2 times, 3 times revenue. And then it's, a question of what the profit margins are of that business, which would then be a net income multiple or EBITDA multiple. There's different ways to value any kind of business. Small businesses are usually valued, super small businesses are valued more on the revenue, albeit they do need to be profitable if somebody's going to buy it and take on a lease obligation if it's retail or whatever else.
Yeah. Mark, most of these deals usually start with a letter of intent. We haven't even covered that. So explain to the folks, what is a letter of intent? What does it usually cover? How does it shape kind of the timing and the sequence of the rest of the business transaction?
Yeah, so the letter of intent is after you've already identified a business that you're interested in. Let's say, and usually the letter of intent is generated by a buyer. So let's say you've engaged a broker, you've gone out there, you've looked at, or you just found a business that you want to buy. Then a letter of intent is a non-binding document typically. There may be some provisions in it that are binding, such as if you're going to spend the time and effort as a buyer to try to buy a business, you may want to have the seller in that letter of intent sign a no shop provision to where they're not going to be shopping the business to others, to where then you get into a competitive bidding process once you start doing some due diligence. And confidentiality and other things would be binding as well in that document. For the most part, though, it's a matter of trying to set the parameters for the transaction, identifying typically these are asset purchases. They're not stock purchases or mergers or like you might see with public companies or large private companies. So there's a reason for doing an asset purchase. It just de-risks it for the buyer, and maybe there's some tax motivation there too. But the long story short is the letter of intent is going to be what you're willing to pay for the business, identifying the assets of the business, possibly having owner financing associated with your offer, and or having a financing contingency if you're going to use third-party financing. Just the basic parameters of the deal so that you can then start evaluating the business based upon what you've offered and how you're planning on paying for it during a due diligence period. And a lot of times, the letter of intent carries all the way through to a closing, and the purchase and sale agreement, which is the official document that deals with the transaction, is signed at the closing with these small business deals. So you're really, there's some risk that can take place, earnest money deposits, things like that you may need to document separately and distinctly or within the letter of intent. But there's a lot of, it owes more than 50% of the deals I do, the final purchase agreement is signed at the closing.
Wow.
And so the letter of intent really governs almost everything.
Yeah. Well, let's talk about the purchase agreement. You just wandered upon it. So now we've moved on from the letter of intent, or at the signing, we're doing both. What are some of the key terms in that purchase agreement that kind of determine how the deal is going to work in practice?
Right. And so, let's say we've got a 2-month timeline in buying a business. So you get a letter of intent locked in. You got your due diligence provisions there. What's going to within the letter of intent, and they aren't that explicit, but just what you're going to be looking at during that due diligence period. During that entire time, you're negotiating, or after the initial due diligence period, they're going to be negotiating the purchase and sale agreement. And that agreement is typically, again, an asset purchase agreement is what it's called. If you're buying the assets of the company. You could do a shareholder or membership interest purchase agreement if you're buying the stock or membership interests of an LLC, stock of a company, LLC, and membership interests. But the biggest thing is this is the buyer's, and the asset purchase agreement is the buyer's insurance policy that is the seller being honest with me and providing me with a transfer of all the property. What happens if not? And what if there is fraud? And there's a key set of terms within these documents called representations and warranties and disclosure schedules. So those are basically the honesty provisions for the seller, where they need to provide you with good, clean, clear information, and they represent that it's accurate. And then they provide essentially a warranty. Everybody knows what a warranty is for consumer product. but I warranty that it is accurate, and there's a consequence if it is not. Now, the consequence is generally suing for fraud or breach of contract if you under these terms. And so the buyer wants to have them very broad. The seller wants them to be very narrow because the seller doesn't want to get hit with a lawsuit. So there's those kinds of terms: non-competes, seller financing, or financing contingencies within the asset purchase agreement. If that asset purchase agreement is signed earlier in the process and not at closing, then the financing contingency would be a critical thing. It's contingent, right? Sign a document with a financing contingency at the closing, and the money is there, then it becomes a moot point. So timing matters with a lot of these documents, but the gist of it is the asset purchase agreement. That's the thing that hangs around for years afterward, and in the event of a problem, you may be able to go back against the seller and enforce terms under that asset purchase agreement in the event of fraud, breach of contract, some component of seller financing, some future event, transfer of real estate, something like that.
Can I ask you on the piggyback on something you mentioned about financing? I know they take many forms on the financing front. You can get SBA loans, equity contributions, et cetera. So what kind of tends to influence the structure on the financing part, especially for a particular deal?
Well, first and foremost, it depends on the wealth of the borrower and the sophistication of the buyer/borrower. Wealth and sophistication of the buyer/borrower. There can be cash buyers out there for businesses because they don't want to screw around with financing. Now, I represent small business people, so they are usually more cash strapped, and so a lot of times debt is prudent as long as it's prudent debt. If you take on bad debt or you have a hiccup, debt can kill you. But a lot of deals have seller financing. So where a seller wants to sell, call it a warehouse distributorship, and for, let's say, $1 million, and the buyer can only has cash for 500,000 or 300,000, whatever it might be, and for whatever reason, maybe they get better terms from the seller, or they don't want, or maybe they can't qualify for, be it an SBA loan or another commercial loan, in order to acquire the project or the business. So the seller wants maximum dollars. The seller may even have what's called an earnout within this agreement, but let's just focus on the financing. So the seller may say, all right, you pay me $300,000 at closing, and then we're going to draft a promissory note of $700,000, and I'll get paid out with interest over the next 1 to 5 years. And that may be a way for the seller to get more purchase price because it's an easy way to get financing. But that seller had better be prepared to really help support that buyer, because that seller becomes a bank the moment that they make the sale. So seller financing sounds great, but if they drive your $1 million business into the ground during the first 2 years of a 5-year note, and then you got to come in and exercise lien rights and other default provisions within whatever loan documents you've got, including the promissory note, all of a sudden you thinking you're retiring, and you're going to have some steady stream of cash flow coming off of that note, and then there's a default. You got to come in and take the thing back over and basically, break your retirement if that was your incentive as a seller. So, there are also earnout provisions that are, somewhat kind of like financing, to where you're going to pay $1 million for the business, but $300,000 is going to be held back. And then it's only payable if the business actually performs as the historical financials showed that it performed. Mm-hmm. So the seller would really have an incentive then to help transition the business, make it profitable. And if the business drops off for, external events or mismanagement, there may not be the full $1 million being paid to that seller, because the business didn't hit an income or revenue benchmark that was forecast or pro forma'd by the seller and or the buyer. So that earnouts are another form of financing. Essentially, it's about proofs in the pudding.
Mark, let me ask you as we wrap here. You mentioned franchises a moment ago. Obviously, small business sales involve franchises, as you know. What other additional steps or approvals come into play when a franchise is part of a transaction?
So, based on the way you're asking the question, I'll just answer it. For an existing franchised operation that's already built out, somebody else has already established the location, and it's got a franchisor associated with it. And that could be anything, a Subway or restaurant, whatever. So the sale of any business, one of the critical things to worry about are, especially with franchises, and because a lot of them are retail facing, there's going to be a landlord, there's going to be a franchisor, there's potentially a lender on the buyer side, there's potentially a lender on the seller side. As long as the lender on the seller side gets paid off, they really don't care. They don't play into it. And then there's the seller. So the buyer needs to be sure that it is communicating and has rights to communicate with the franchisor, who they're going to have a new franchise agreement with them, or an assignment of the existing franchise agreement. The same thing for the lease. You're going to take over an existing lease or draft a new lease, and you're going to have a relationship there. So when you're buying a franchise business, you got to make sure you get permission from all the parties that are involved. It isn't just the seller. The sellers a lot of times try to gloss over that. Don't worry about it. We'll get that done. They say it's cool. And then I've seen problems, either due to credit underwriting or, if the person has a bankruptcy in their history, that's the buyer. There's no guarantee that all the people that can, quash a deal are going to cooperate. So you gotta make sure that you're talking to everybody before you invest 2 months of your life underwriting and the due diligence of the property or the business, and then you find out that one of the third parties does not want to cooperate, and then you're dead in the water and you've wasted all that time.
Yeah, it's good advice for people out there. Mark, I can't thank you enough for breaking this all down for folks. Truly appreciate it again.
Yep, thank you.
That's it for today's episode of the Atlanta Business and Commercial Real Estate Law Podcast. If you're buying or selling a small business, you need help understanding the deal documents. I needed help. Mark is here to break it down. He can help you with the documents, the negotiations, the closing process. All you got to do is visit battlesonlaw.com to connect with Mark. Thank you again for listening. But before you go, do me a favor, hit like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.